Hello, my name is Robert Reeves. I'm a South Carolina workers' compensation attorney. I'm making a series of videos to give you an idea of what to expect at certain workers' compensation case events, namely a hearing in different scenarios and mediation. Today's video is about mediation. Now, to give you an idea about my background so that hopefully what I tell you on this video has some credibility, I've practiced South Carolina workers' compensation law now for 31 years. I started out my career as an insurance defense lawyer, and I have attended countless mediations. I have become a huge fan for the simple reason mediation works and mediation gets cases resolved. Also, it is the last opportunity for you to have some input and influence on the outcome of your case. Now, mediations are set up by agreement in terms of who is going to be the neutral third party. I generally like former defense lawyers or even practicing defense lawyers for the simple reason they focus on workers' compensation law, they know what they're doing, and frankly, the insurance adjusters are more apt to listen to a defense lawyer than just a regular adjuster or someone who really has no experience in workers' compensation law. Now, the night before, I will literally go through every page and every line of your medical records and every other document in your case so that I have a full and complete understanding of your case. I will highlight those areas that I think benefit our position, and I will prepare a presentation for the next morning when we start mediation. The insurance defense lawyer will do the exact same thing with a completely opposite focus. Now, we'll meet at the mediator's office or sometimes at the other side's office because they may have more space. We'll meet in one large conference room where everyone is present. You and I will be there for the claimant side, the insurance defense lawyer, possibly someone from the insurance company, and or someone from the employer may be present on the other side, and then the neutral third party, the mediator, sits at the head of the table. The mediator starts by explaining to you, because you're the only one who has never had experience in this, that they have no authority to force anything or order anything. They are strictly there to try to get your case resolved by carrying your demands and the insurance company's offers back and forth until hopefully we can reach an agreement. They will also tell you that everything said in mediation is completely confidential, can never come back and be used against you in a hearing or any other forum. And if there's anything that you want to keep private from the other side, to simply let them know, and they will not share that information. Then the lawyers give a presentation. The claimant's lawyer, me, would start off by giving our presentation of your case. We put the best spin on it, and then we always end with that we are cautiously optimistic that we can reach an agreement. Then the defense lawyer will do their side where they present the best spin for their position, and then they also pledge good faith in trying to get this case resolved. Then one side or the other will go to a different room. The mediator will stay with the claimant, and we will start with our view of the case and with an opening settlement demand. It will be a very high figure, but usually that's not enough in terms of all that you've been through, but it is this highest offer we can make given the laws and the restrictions under workers' compensation law in general. Now, the mediator will then take that offer to the other side. They will gasp and then come back after a period of time with something equally unreasonable and a low offer. And then we will go back and forth countless times, who knows how often, until we reach a final figure that they are willing to offer and pay voluntarily. Now, most mediations last about half a day, sometimes a little bit longer. It just depends on the nature of the case, the complexity of the case, and how hard the insurance company wants to dicker. Now, what I tell everyone is once we start with the initial settlement demand and initial offer, you can probably go take a nap, because other than that, it's just a series of intermittent offers and demands. The only figure that really matters in mediation is the very last one, and that is the figure that they will call the maximum authority, and then oftentimes we will ask them to go back for one call, special authority, to get the case resolved. Now, once we have that final figure, then your lawyer and yourself will have a discussion about whether that's a good offer or not, and that is based on whether or not they think you can get more at a hearing. In most cases, you can do a better job at mediation than at a hearing. But it is always up to you. You make the final decision, of course. It's your case, it's your life, and you know what is best for you after we give you our guidance and counseling. If mediation is successful, then we will write up a temporary mediated agreement, and then something more formal called a clincher agreement. Clincher settlement agreement will be drafted by the defense and sent over to your lawyer, and after review and any tweaks that need to be made, then they'll sit down with you to get signatures. Once the clincher agreement is signed, it is sent to the South Carolina Workers' Compensation Commission for approval, and once approval is reached, then you get your money. Every serious case is a very long and difficult process. Mediation can end that process more quickly and get you on to the next stage of your life. If you have any questions, you're welcome to call me directly, 704-351-7979, or you can email me, robert@rjrlaw.com. Hope this video has been helpful. More to come.